Hello, everybody. You are watching a special episode of the Divorce Happy Hour podcast. Joining me today is special guest Jessica Smith Bobadilla. She's an immigration and human rights attorney with offices in Fresno, Oakland, San Francisco, and Los Angeles, California. But she can represent you anywhere because of the nature of immigration law, and we're going to talk more about that. Thank you for joining me today, Jessica.
Thank you, Christina, for inviting me.
Well, I really would like to hear more about just general basic immigration law. I'm a divorce lawyer, so this is something that comes up very occasionally, and it's not my area of expertise. And I personally don't really know a lot about it. So this is information that is interesting to me, but I think will be of value to anybody who's watching and needs to know some of this stuff. So thank you.
Thank you.
So let's kind of start out with very basic information. If somebody wants to come to the US, how the heck do they get in?
Well, there's a number of different ways that people can immigrate. They can immigrate through a family member, and that's only certain family relationships. But there is a path through certain family members, including a spouse. There's also certain paths through employment-based immigration or through an employer. But again, there's certain restrictions and exceptions to who can immigrate through an employer and when and under what circumstances. And then there's kind of special provisions for things like asylum, for things like people that might have been victimized or abused by a US citizen in a domestic relationship, even if it was abroad. There's sometimes, very unique things that come up like that. But most people that immigrate to the United States immigrate through a family member. The second largest group immigrate through an employer.
Okay. So even more basic than that, if somebody wants to come to the US from another country, do they have to get a visa or can they just get on a plane and come here?
No one can just get on a plane except to visit Europeans, certain Europeans and certain other countries. I believe Japan was or is still part of the visa waiver program too. There are certain countries that don't need to go through the formal visa process. They can just go and apply, or not even really apply. They just basically buy a plane ticket and show their proof of, let's say, French or Italian citizenship and can get on the plane for 90 days with a very limited restrictive visa.
So basically a passport.
Passport and a visa. So a passport is what proves your citizenship. So I'm a US citizen, so I have a US passport. The visa is what is a permission or a license to enter another country. So I might even, I don't think US citizens need visas to many countries, but I may need a visa to enter certain countries, a license or a specific permit to enter, which is separate from the passport, which is your proof of citizenship.
So can pretty much anybody get a visa if they just want to come on vacation to the US?
Very difficult to get a visitor visa, and a lot of requirements about proof of ties in the home country, proof of assets in the home country that would lend people to believe that you would go back. And then there's also just cases where people have all of that and they still deny because they believe that the person would stay. Or I've also suspected that they sometimes have just given out too many visas previously, and visitor visa, there's no right to it. It's totally discretionary under US law. So it could really be denied for any reason. They don't have to even give, I think they give a reason, but the reasons are very vague that they're allowed to give for denying the visa, visitor visa.
That's interesting to me because as an American, it's pretty easy for me to go wherever I want to go. I don't recall ever having to even apply for a visa any place that I've been. I've been to a number of countries in Europe and I've been to Colombia, Mexico, and I never had to fill out any application for a visa. So I've really been ignorant to that fact.
Right.
So we see so many tourists though. So those people from other countries and those people have all gone through this visa process.
Yes, they've either applied for what's called a visitor or tourist visa, and there's two variants of that. There's one for business and there's one for pleasure. So there's one that would just be to vacation or visit family members. There's another that's more business oriented to explore business opportunities. or to expand your business, abroad by making contacts with suppliers or affiliates within the United States. And so there's two variants of that, but all of those people that are visitors have entered, unless they're from some of those select visa waiver countries, then they were just allowed to kind of fly in. But again, that visa is only for 90 days for those countries. It's very restrictive in terms of your ability to change to other visas without going back. Whereas a regular visitor visa, when someone sits down in a consulate, applies, and is granted that visa, then gives them much more latitude in terms of being able to change things up once they're here and apply for other things.
So what happens at the end of the 90 days if they don't leave, if they don't go home?
So then they start to accrue what we call unlawful presence under immigration law. And there could be enforcement. Now, both for a number of reasons, enforcement for people that overstay on visas that they lawfully entered on is not really something that is at the top of our list of worries as an immigration lawyer. For reasons that are maybe partly political, partly complicated. Most enforcement that we see, at least in most of the communities that I've worked in, is against the undocumented, the people that come into work generally in the area that I practice in agriculture, and most raids and things like that, and even visits to homes and things like that generally have been targeted at people that were undocumented. That's not to say that people that entered with a visa have never been the subject of enforcement. They are. But it's not very common that, okay, your visitor visa expired, or your visa waiver expired last week, that ICE is knocking at your door.
Yeah.
With the pandemic, we have just less enforcement. They're really only enforcing now on things that are people that are, deemed dangerous, criminals that they would like to remove. Because, just the constraints of going into homes with COVID when there's children there, and having, adults that are in and out of different homes going in, is complicated if the government were to do more of that than absolutely necessary until we have the pandemic under control.
And who are these powers that be that are reviewing the visa applications?
So I worked at the State Department. So this is interesting, my very winding path to becoming an immigration lawyer. I worked when I was in law school at the State Department in Washington, D.C., and I worked in Cuban affairs, which is kind of a rare department or area, because at the time I worked there in the 90s, US-Cuban relations still were not normalized to the degree they are now in terms of travel and other relationships. And so when I worked there, we would physically carry, because Cuba had special restrictions on, only certain educational programs, people could come back and forth, and certain family ties. But I would carry passports from our office down to a visa office. Now, I assume that things with, increasing technology aren't like physically someone carrying passports around to grant a visa. But, there's a review in each consulate. Each embassy has a consular section, at least in one city in every country that we have diplomatic relations with. And the consular officer in that role has certain criteria, has been trained on the Immigration Nationality Act and on the immigration laws, and reviews those applications with a staff of people, and they give a yes or no. And they also conduct interviews. So it's quite a bit more formal than what you and I have to go through when we go for a vacation in Mexico or almost anywhere in the world, right? As US.
Yeah, that's quite different.
Yeah. And then there's also, just in what we were discussing before, there's really a difference between, so the US law, at least, I'm not sure about every country in the world, but the US law makes a big division between visitor status and immigration. So visiting or visiting to study or visiting for a temporary work situation, they view as completely distinct from the immigration process, almost to the degree that, really to the degree that if you go in and you apply for a visitor visa and you say, yeah, I may want to marry my partner who lives there, they will deny the visitor visa because that shows immigrant intent, and you're not applying to immigrate. You're applying to visit. That interview, that's the nature of that interview, is that they're deciding whether you're allowed to visit or not at that time. So it's pretty strange. It's kind of this fiction that almost people are either intending just to visit us or just for temporary work or for temporary study, or they're intending to immigrate. And when those two things mix, then it's usually very bad for the applicant, because there's very few areas where you can have what they call dual intent, where you can be applying for something temporary, like a visit, but also have the intent, express the intent to immigrate long term. And sometimes they even dig into things. They'll dig into people's social media.
Mm.
They'll ask, like, are you coming to get married? Because this isn't the visa for that. You have to go through a different process.
Well, that's really interesting. So if you are coming to get married, are you definitely getting in if you're coming to get married?
So then you would apply for a fiance visa if you're still fiancés. And you would apply, if you've married abroad, you would apply for an actual green card or an immigrant visa from abroad to enter the country, and then you'd receive the green card. But the processes are longer generally than in applying for a visitor visa. And some people that decide to marry US citizens, they already have a visitor visa. So they think, well, I can just come in, get married. But the problem is at the port of entry or in the airport, if they say anything like, well, I may get married this trip, my girlfriend and I may get married, or my boyfriend and I may get married, then the officer at the port of entry is supposed to deny the entry and turn them around, because they're expressing something that is not what they've applied for. So it does get very technical. And there's also other cases where people get married. Maybe they're reunited with someone. They come in, they tell the officer, their officer asks and makes notes and says, why are you coming in? They say, well, I'm just visiting friends, going to some events. And then maybe they end up marrying within, like, especially if it's within a short time of the entry, like within 30 days or so. That raises a red flag, where then when they apply for the green card, with the spouse, they really dig into what was going on. Like, why did you tell us when, 30 days before you got married, that you were coming here just to attend some events, because you married soon after that. So there's a lot of technicality to it, a lot more than people think. And there's a lot of areas where people get kind of tripped up, because for some reason, I think there's this false sense that about immigration law, that it's just forms, that it's
Yeah.
forward, that you just read the form and you fill it out. And if you're honest, I mean, not that you shouldn't be honest, but I've sometimes directed people who are being completely honest, exactly how to answer the question at the port of entry, exactly how to answer the question in the interviews. There's a lot of law to it,
Yeah.
really. That's why you retain and have a lawyer, is so if there's technicalities, just like in any area of business or whatever we're doing, that you're within the as to how the technicalities benefit you, versus outside of that, which can be really detrimental to people's lives.
So what if they are coming to get married? Isn't it easier to just say that, or is it actually harder to get in?
They have to have the right visa for that. So what commonly occurs is they have a visitor visa, and that is not the visa for marriage. They have to have either a fiance visa, or they would have to apply abroad, get married abroad, and do that whole process abroad, and basically already already entering as an immigrant. So there's just there's a visa for everything. It's like, kind of, if you look at USCIS or the State Department's links on this, it's kind of alphabet soup. There's an O visa, there's an M visa, there's a P visa, there's K visa, which is the fiance, K1 is the fiance. There's even variants of the same letter sometimes, which are things that are distinguishable in some way under the law.
Wow, it's even more complicated than I actually realized. So, can you explain to me what asylum is?
Okay, so asylum is when somebody has a fear of persecution in their home country. Persecution is something that sounds like, it would be just, there would be a textbook definition, but unfortunately, that's one of the most litigated things as to what constitutes persecution. And really, to have a strong asylum case, there's a number of requirements, but you have to have the strongest type of asylum case, you have to be able to prove past persecution in your home country. And if you prove past persecution, then there's kind of this presumption that then the government has an opportunity to rebut that you would face a fear. The standard is called a well-founded fear of future persecution in your home country. If you can't prove past persecution, it's often very difficult. There's some limited ways you can prove future, like if there's been a civil war in your country or some major event since you left that would impact your group or somebody like you. But asylum is very technical. Really, the whole idea came out of after the Second World War. There was, a different orientation towards preventing what happened during the Holocaust from ever happening again. And the asylum law was developed from that point forward. So there's a lot of case law. There's a lot of litigation of asylum claims up to the circuit court levels. And there's a lot of precedents that end up changing things. And what's confusing too is if I have a client in California that's within the parameters of what the Ninth Circuit said about persecution, past persecution, they could technically be from the same country as someone that you're representing in New Jersey in the Third Circuit and be subject to a different rule.
Oh, that's kind of weird.
Circuit splits on certain immigration related, important big things. So it's odd. I've had people say to me, well, so and so, applied and this, they got denied. And I'd say, well, where were they living? And, the Ninth Circuit law is generally the most favorable towards asylum seekers and immigrants in general. There's some exceptions. I mean, the Second Circuit has some strong case law, and there's stuff that has obviously come out of other circuits that is favorable, the 10th and others. But it's tough because how do you tell someone that their case could be quite a bit different if they were living somewhere else?
Can you do that? I mean, can you tell them to move?
No, because I think it's unethical to suggest that you forum shop, but I do educate people, especially if they've just arrived. Sometimes someone's staying with, an aunt or something in Texas. And, the Fifth Circuit isn't probably the most progressive when it comes to, immigration law. There's some others that are probably even less. But I'll just kind of explain the differences, and I'll say, so I don't know if you all are, permanently there or if that was a place to land, but you should know, before you make more decisions about where you're going to live, that the law is different from area to area because of the way our system is structured with federal judicial circuit. And the circuits make their own decisions until, as we know as lawyers, sometimes there's a split that then the Supreme Court decides to take up and settle, but
yeah.
that's, that sometimes happens. Sometimes circuit splits just exist, right? Forever.
Yeah.
You to get more extreme, because you have like half of the circuits going one way and half going another, and then one kind of just doing its total own thing.
Well, that's kind of crazy that you could really get such a disparate difference depending on what circuit you're in.
Yeah. And in some cases it's more extreme than others. Sometimes the definitions or the case law are slightly different, but in others there's been, pretty significant differences in those types of things. And I think for some reason too, maybe, I don't know the exact statistics about how many immigration appeals are filed up to the federal level, but I know the Ninth Circuit has a lot. A lot of its docket is immigration appeals, and I've prevailed in several at the Ninth, and I've argued several. They've selected, for some reason, I don't know what I'm doing, but they're selecting a lot of my cases for oral argument, and I have another one in February.
Is that unusual?
I mean, it's kind of exciting for me because I feel like, it's kind of like why you become a lawyer is to do something at that level, and I think the first one I argued was 2007. So I was about 5 years into practice. But I think it is unusual, but I studied a lot of policy and I studied a lot of I am a human rights background too. So I think I tend to make a lot of out of the box arguments because I'm not just reciting the law, and
Yeah.
of course I'm doing that. I'm pointing to the record, which is what we do in appeals, but I usually make an argument or two about country conditions that might be a little bit out of the box, or about what the law should be, like kind of more a policy-based argument, which especially the Ninth likes, right? I mean, right. So Justice Sotomayor got in trouble, but for saying, well, at the Court of Appeal, we make policy, or when
So are they doing everything by Zoom now? If you have oral
I,
argument?
I think the oral argument I'm going to have in February is Zoom. I think so. They haven't firmed up the date yet, so I think I'll get the formal instructions. Once they firm up the date, they sent me a notice to let them know of any dates around that time that I'm not available. But I've heard that several people had Zooms since COVID started.
And you and I have talked about this before. Even though you're in California, you can really represent anybody anywhere in the
Yeah.
US.
Mm-hmm.
So how were you doing that before COVID, before that was a thing? Were they doing Zoom, or would you have to travel sometimes?
I would travel, and I've had asylum cases, especially from countries where, I think because I do have a human rights background, I've been asked sometimes to go to like Chicago once for a case from Turkmenistan, which I won. So I think sometimes people have come to me from far and wide when I won cases for other people they knew, especially if they were from countries where they didn't think that if they just walked in somewhere that an attorney might necessarily know the country conditions, because I am known for going deep into the country conditions. I think, because that's part of what you study as a human rights advocate or lawyer, is looking at the country indicators on human rights, which asylum is really a variant, I think, of human rights law, as
And
much as part of the US immigration law.
it seems like, and correct me if I'm wrong, but it seems like usually when someone applies for asylum, are they already here in the US?
The definition is the same. If someone's applying abroad, they're a refugee. But really, it's very, very difficult to apply for abroad from abroad unless you're like in a refugee camp. Like after the Vietnam War and after the Southeast Asian, wars, there were refugee camps in Laos and Thailand, and mostly in Thailand because Laos was communist. And a lot of the clients that I've represented from Southeast Asia were in those camps and then were processed for permanent residence or for refugee status and then permanent residence in those camps. Now, sometimes I've represented them because some have gotten in trouble with the law after they came here. Others might have had complex situations where then they had family in Europe that got settled there, ended up going there, not getting, these weird international legal situations where they're not really settled anywhere. But most people that process abroad for asylum, it's classified as refugee when it's abroad, and most are processed through the camps. There's exceptions. When I was at Columbia, I did some advanced human rights work, and someone that was in an advanced seminar with me, I think he had been granted refugee status through the State Department because he was an activist in Southeast Asia, I believe in Burma. And so sometimes the US government will identify someone, particularly if they're helping the US or they're a democratic activist, maybe in a country where they're in danger and they're furthering democratic interests. And the US government may already have a relationship with them because of local politics, but will sometimes extend, protection to someone in their family to come into the United States as refugees. But that's rare. You also have to be a pretty prominent person to get that kind of treatment in most cases.
So I didn't even realize that there's technically two different statuses, refugee versus asylum.
It's the same standard, though. It's still that you have a well-founded fear of persecution based on a, characteristic that you can't change, that's ascriptive, that's like kind of like when we talk in US constitutional law about strict scrutiny, it's kind of the similar characteristics that trigger strict scrutiny, but a little more broad. So when you apply for asylum on the application, they talk about, are you persecuted based on your race, your religion, your nationality? And nationality would be different because you could be like, a Chinese national living in, maybe a neighboring country, but you could technically be kind of the same race as some of the people there, but because of your national origin, you could be subject to more persecution or scrutiny. Race, religion, nationality. There's something else called membership in a particular social group, and that's very amorphous. That's also very litigated, and it's very different often from circuit to circuit what social groups might have been exactly recognized. So the social group can't be tied to the persecution, so it's very odd. So
Hmm.
some points, let's say gay Mexican men, that would have been a social group that was recognizable. Now, some judges, including in the Ninth Circuit, are saying, well, there's gay marriage in Mexico City now. If you can relocate to avoid the harm too within a country, they require you to do that, or that's something you have to get past an asylum case. So something like, women fleeing cartels may be too broad because it kind of includes it would kind of depend, but it's hard if it gets too much into action. It kind of has to be the characteristic that characterizes a social group. And as an immigration lawyer, as an asylum lawyer, you can define new social groups, but they'll often look back to precedent and to other cases to see if something similar was either accepted or rejected in other cases. And it's not uncommon to try to throw out a lot of different social groups in certain cases to see if one sticks and one resonates with the judge. Political opinion is the one that is really, when I get a political opinion case, and I have a few now, those are, I don't want to say the easiest to win, but that's kind of the core of asylum, right? That you have a political opinion that's different. I mean, that and race and religion are kind of the core. When you get into social group claims, particularly from Latin America, it gets a little more amorphous because it can't just be crime. So if a cartel comes and murders your whole family, and they also target multiple people in the neighborhood, but there's nothing said by anyone, there's no notes left, there's nothing said by anyone as to why they focused on your neighborhood or these group of families, it's not really asylum, unfortunately. It can be horrific killing. Now, sometimes if it gets to a level of torture of people that are close to you and you have evidence, sometimes a judge can grant something under like the Convention Against Torture, but you have to show that the government was involved or had, kind of a hand in it, or consent or acquiescence. So on the asylum application, another thing to know is that you're technically filing for asylum, for something else called withholding of removal, and then for something else called relief under the Convention Against Torture. So there's three kind of separate standards. Asylum is actually the lowest evidentiary threshold to prove of those three, but sometimes when there's not a strong enough tie to like one of those grounds, but someone was tortured, or there's evidence that the person would be tortured, maybe because they were affiliated with something that's hated in that society, then sometimes a judge can grant one of those other forms of relief, which are a little bit looser in terms of the requirements of the tie between the group and the harm. So the asylum is probably the most complicated. A lot of people that dabble in immigration, or even some immigration lawyers, take asylum cases. I became an immigration lawyer to try asylum cases. So not that I'm not interested in other things, but I that's my strongest, I think, interest, and my probably strongest area within U.S. asylum immigration.
Well, for anybody who's interested, you and I did sit down and have a lengthy conversation about what your history, your family history, and why and how you became a human rights attorney. So if anybody is interested in listening to that, it's on the Wake Up Call podcast, and I'll put a link in case people want to hear more about that, because you've sort of alluded to why you're so passionate about what you do, and there is a story behind it. So if people would like to hear more about that, I'd love for you to listen.
Great.
So if someone is just living in a war-torn country where it's unpleasant to live there, it can be dangerous to live there, but it's not something specific to them where they could demonstrate asylum, what do they do? What is their recourse?
If they don't have family members that have petitioned for them or could, really their only recourse is to try to get to a U.S. border and apply for asylum at the border. There was during the Trump administration, there was a lot of talk that people, the mothers with children that were presenting themselves, were bringing their children here illegally. It's not an illegal entry under international law. Conventions and international commitments that the U.S. has signed, which have then been integrated into U.S. law, actually say that presenting yourself at an international border is within U.S. law. If you say, I'm afraid, and then the U.S. can conduct a process, right, of review of that. But that was one of the things that bugged us the most as immigration lawyers. It's not the same to cross a border without a visa as to present yourself and say, I'd like to apply for this remedy that I know exists in this country.
You mentioned earlier there's an employment visa, and we sort of skipped over that. So what does someone need to show to get one of those?
So there's certain categories that are shortage, like nurses, and there's certain things that are sometimes designated shortage. Those are a little easier to get. Now there's non-immigrant employment visas, like the H-1B technical visa, and that's a very hard visa to get, both because there's over application for it, so there's been lotteries. There's also been talk that we need more H-1B visas. So that's a lot of people come in on some kind of a professional visa if they are professionals, like the H-1B, and then their employer, if all goes well, they can keep extending it for a number of years, and then they can apply for a green card while they're extending their non-immigrant visa. The process is pretty complicated for getting a permanent, green card through an employer. In most cases, unless you're a very exceptional status and ability, the employer has to recruit and show that they cannot find a U.S. worker and document that. And then they have to go through another petition process, that's the I-140. And then they have to finally apply for the green card. But that can take time. And sometimes there's strange contradictions between the ability, to keep extending the status, or people also lose jobs in the middle of these processes. And sometimes there's nowhere else to go and they have to leave the country. So it's also a very involved process. And some employers, when they hear what they actually have to do, sometimes they just think they need to sign, a piece of paper or something. It's a lot more involved than that. And the employer, not to scare anyone, but can also be audited if they don't do the recruitment properly or other things. And there could be potentially penalties if the audit doesn't go well.
And I know there are a lot of companies that do this all the time, like big pharma companies or tech companies. They're sort of used to that. But let's say you have a small company. Let's say that I have a law firm, which I do, and I have an old relative in Sicily that I want to come and work for me and teach her how to be a paralegal. How's that going to work? Can I just sponsor her to come in?
Generally, the person would have to have experience and be able to document that in the area. And even for visas that aren't highly skilled, or for areas that aren't highly skilled, it may be possible if they had some related experience and the right credentials and education, but it's definitely not like usually a very quick, easy process. And usually you have to show that you need that worker and that they have some skills that you could not find a U.S. worker to
Okay.
fill.
So I probably wouldn't be able to show that in that example. So what do we do when we're moving from visa to green card? What do you have to show to get that?
So in an employment-based context, you have to, again, unless the person is very, has got a temporary visa that's for someone with outstanding ability or exceptional ability, then usually you have to do the labor certification process and do recruitment. And then you have to show that there's no U.S. worker available through the recruitment. And then once that's done, there's a petition to file. Sometimes there's also dates to wait for, like in the family base, there's this too, where you then have to wait for a date to become current. And and that can take a lot of time in some cases. And then you finally apply for the green card as kind of the last step in the process. But it can be very involved. Sometimes, like now, a lot of the priority dates are current for employment base. So that can make things roll forward a little bit faster. But there's other times and for certain countries where, for example, India, where certain categories are backlogged significantly for years. So you have people trying to extend their non-immigrant status for years and years and years. to finally wait for that date to become current to be able to take that final step.
And if you have a green card, you are considered a permanent resident?
Yes, then you're allowed to live and work in the United States. You're allowed to travel with the green card in your passport, but if you stay out more than 6 months, there could be problems in getting back in, and definitely if you stay out more than a year.
Oh, okay. Oh, that's interesting. I didn't know that.
Some people are like, I'm going to get the green card and then go live in my home country and then kind of come and go as I please, and that's not what it is. You can quickly lose it by doing that.
Well, my next question was going to be, is there some way that you could lose the green card once you have it, or if be deported for some reason?
Permanent residents can be deported, and often they are for crimes. They can also be detained for long periods. So it's definitely not, it's permanent, but it's subject to being revoked. So I always tell people until the day you're a citizen, it doesn't matter if you got your green card when you were 1 year old. It doesn't matter if you, you know, whatever you feel like you're from here. It doesn't matter if all your family members are US citizens. Until the day that you're sworn in as a citizen, it's always subject, it's more like a license that's subject to being revoked, by an immigration judge. Um, now, it can't be revoked. There are cases where permanent residents are detained and they just say, I don't want to deal with this. I'm going to sign to basically be removed, to give away the green.
Mhm.
But they, if that doesn't happen, then they are supposed to be put through a certain process.
So it's permanent, but not really.
It's subject to being revoked based on the rules, yeah, and the law.
And I might be going into way more detail than you and I had even discussed, but if someone has a green card and they commit some kind of criminal offense, do they need to be worried about that? And what if, I mean, speeding ticket, you don't have to be worried, right?
If it's
Or,
like fraud or anything like financial crimes, fraud, anything violent, anything, you would want to consult with an immigration attorney. Even a DUI, if there's a crash or there's
yeah.
bodily injury of anyone, it could be your sister who just broke her arm, when you crash. It doesn't really matter who it is. If that, then that kind of kicks it up a notch, and you want to start consulting to see, even if they haven't, contacted you, what are the odds? What's the likelihood that I could kind of get, more consequences from this or at some point? Because many people, some people are handed over to immigration. And again, one DUI would be an extreme example, but if there's multiple and one did involve bodily injury, that could be something that at some point the government wants to investigate further as to whether you should still have your green card. But often what happens is someone, has some kind of criminal incident. Maybe it's like an embezzlement. They think, okay, I did community service and probation. I'm done. I paid restitution. The problem is when people come back in from a visit abroad with their green card, that's often when it's flagged.
Mm-hmm.
And sometimes in extreme circumstances, they can be detained, even if they're a permanent resident. And in some cases, they're not eligible for bond, depending on the type of crime it was, if it was a drug crime or a violent crime. There's a lot of different rules that can apply to this, but I think if any non-citizen is convicted of a crime, probably if it's one DUI, it should be okay as long as everything's dealt with. It wasn't an aggravated DUI. But when you start getting into multiple things or anything much beyond,
Mm-hmm.
you're at least going to want to consult with an immigration attorney to see what your chances are of facing consequences at some point for this activity.
What if someone got a restraining order against you?
Restraining order alone because it's civil, would not subject someone to immigration enforcement or consequences. But if they violate a protective order, domestic violence protective order, then there could be immigration consequences for that, including there are people that have been removed depending on the timing of when that occurred, how long after they got the green card, if they have other offenses and the nature of that offense.
Well, how do the powers that be, I guess ICE, how do they find out about it?
So sometimes now there's a lot of controversy about this because sanctuary cities have agreed not to really, share information between law enforcement and ICE. But other jurisdictions do share information or don't have this same degree of screening off. There's also, again, people have to apply to renew a green card every 10 years. They take biometrics or print, so sometimes it's there. Sometimes people apply for citizenship thinking this wasn't a big deal. I'm just going to apply on my own, or someone helped me fill out the paperwork, not a big deal. I'm going to apply. And then they realize that they're now, sometimes they can even be put in removal proceedings or detained because ICE is now aware. Other times, again, depending on the jurisdiction and the circumstances, ICE or enforcement is aware from the time that the conviction occurs. And some people never leave the jail, really. They're transported between criminal custody and ICE directly, and then are detained by ICE. Even permanent residents face that.
So what if this happens to somebody and they have children, minor children, and there's a single mom or single dad? If they end up getting deported, do the children have to go with them?
U.S. citizen children do not have to leave the United States, nor do children with green cards. Often, if the children are undocumented, there's no effort by our government that I've seen, unless maybe in the child detention context, if the parents were removed, then probably there was some effort to reunite the children with the parents. But I haven't seen a lot of enforcement against children, in that way. At the same time, most people do take young children with them, unless it's like the father is removed and the mother's able to stay behind and work or live with other relatives.
Yeah. Well, as a practical matter, if there isn't anybody to care for the children, I guess they have to take them.
Yeah. Right. Yeah.
Okay. So then the next step would be citizenship. What does someone have to do to get citizenship?
So citizenship generally involves 5 years of time with your green card. And the other requirements are that you've established, there's a residency requirement that you haven't been out of the United States for significant periods. Now, you can be out for, again, a short visit, but you can't be out for more than half the time. And again, that 6 month and 1 year at one time are also kind of important because those trigger different rules that could lead an officer to suggest that you're actually living in another country, or you're just kind of visiting here, depending on the severity of the residency disparity between the US and another country. The other things that are looked at are obviously any criminal conduct. Other things can be looked at for good moral character. There's a good moral character requirement, like failure to pay child support, failure to pay taxes, failure to file taxes. There's a discretionary element, and then there is a civics and history test. And the Trump administration just increased the difficulty of the test, or the number of correct answers you have to pass. So there's some situations where people that are married to U.S. citizens and have been residing with that U.S. citizen all 3 years can apply after 3 years, but most people have to wait 5 years from the time of their green card.
So that's when we've seen those movie scenes where the couple is being interviewed and to make sure it's a real marriage, and asking them, what color's your toothbrush and what side of the bed do you sleep on? Do those things really happen?
Those are some of the questions that I ask. Yeah. And there's they do separate people. That's not usually at the citizenship stage. It's usually at the green card stage. Okay. And that there's something called a Stokes interview or marriage fraud interview, which allows the government to separate the parties and ask them the same question. The benefit of having an attorney is the attorney can be with both. I had a marriage fraud case once where the stepson was also separated from his stepfather during the interview, and they were asked the same questions, and same with the mother and father. We got them through it, but I think it would have been, I chimed in a few times because the questions that were being asked were not exactly the same as both. So if you don't have a very careful interviewer, you don't have an attorney there, then it's just you and the interviewer, and you could get different questions asked and then a denial based on a disparity in answers where the same exact question wasn't asked the same way. And with translator, that can also be really detrimental if there's an interpreter being used, because then you have another filter that it has to go through, right?
Yeah. So since this is the divorce happy hour, we should tie this in somehow to divorce. So I get clients who will come in for a divorce and there's some issue because the other spouse has a visa and I guess is going through the application process to get their green card, or the divorce somehow has an implication for them from an immigration perspective. Can you speak to that? Does divorce raise some immigration issues?
Yes, divorce can raise a lot of immigration issues. One issue is that if partners or spouses get their green card through a US citizen, and then there's a divorce before there's a 2-year conditional green card that's given in all marriage-based cases. And if the divorce occurs or a separation occurs before that 2-year mark, when a new form has to be filed with supporting evidence, then it can create a difficult situation where the person that is the immigrant has to apply for some kind of a waiver to make their immigration status permanent. And one of the things that can be cited is abuse or extreme cruelty. There's also a case for a finalized divorce where the marriage was entered into in good faith. But there are cases where, the good faith bona fide exception requires that the divorce be final. And as we know, divorces take, in California, it takes about 6 months. I'm not sure exactly what amount of time it takes in New Jersey.
Depends how quickly they can
Agree.
agree on a settlement.
Yeah. So there's a lot of levels to it depending on when it occurs, and you can find people in limbo. So it's really important that if your status was linked to your spouse and you divorce, and you are an immigrant, or a refugee or an asylum seeker, that you quickly consult with your own attorney. And even if you had an attorney with your spouse, an ethical attorney will not take a case, even if it wasn't a contentious case, or it was an easy case when you were trying to immigrate through your spouse. An attorney should not take a case just for you if you're now divorcing that person, because the attorney was acting as both of your attorney. So it's a clear conflict of interest.
Oh, that's interesting. I didn't know that.
Mhm.
So if a couple is getting a divorce and it's amicable for the most part, so neither one of them is trying to jam the other one up in terms of immigration, because I've seen them want to intentionally, but then I've also seen cases where they really want to help the other party get whatever immigration status they need. Can they do that? Is that frowned upon? Is that considered a fraud?
It's fraud because you go into an interview in most of these, or at least you have to sign a declaration and a form as to where you're both residing. And the removal of conditions, or that 2-year step that I mentioned, does specifically ask, where are the two of you residing? Are you still together? And if you say yes and you're not, all the immigration forms are based and grounded in federal law. They're under penalty of perjury. So the whole idea is that you're perjuring yourself to the federal government. And if you go into an interview and then are sworn in and then further perjure yourself, that's a whole nother level. It's amazing to me how many people come in and say to me, well, we're just going to go in and say this,
Mm-hmm.
with really no recognition. And even other attorneys will say, well, can't they just, pretend like they're, I'm like, I'm not a part, well, I'm not going to be there.
Yeah.
Do whatever they want. But,
Yeah.
I'm not interested in representing people that are trying to lie to the federal government.
Yeah, I think that a lot of people, just maybe from pop culture, have this perception that lawyers just lie all the time. I mean, there's a million lawyer jokes about it.
Well, and I think also some kind of a perception that getting the green card through lying about marriage or relationships isn't really that big a deal, because there's a lot about it in popular culture,
Yeah.
right?
Yeah.
And when I really tell people, it's like you were in a federal court. If you go into that interview and you lie, it's pretty similar to being, and you're signing these forms. It's similar to falsifying your tax return and then going into a court and lying about it, a federal court. And then sometimes things start to click, like, oh, well, I thought, I know my neighbor did that years ago, and then divorced, his then wife was his friend or whatever. They had some kind of arrangement worked out. So it's pretty amazing. But when you tell people, and there have been cases where often the people that brokered these kind of things face consequences, but there are attorneys that have been gone away to jail.
Yeah. Yeah. So the attorneys are held to very high ethical standards. I'm not sure that a lot of people realize that.
Right. In a lot of areas, in your area as well, right?
Yeah. Yeah, oh, absolutely. Yes. So, final question. We went into a lot more than I actually intended. So, thank you for being such a good sport about exploring these topics with me. Um, we're going to have a new president. What, if you can, what are your predictions or your expectations in terms of some policy changes regarding immigration?
Well, I think, and I cannot be happy enough about this. I think child detention will probably be gone unless we don't know where someone's family is. I mean, at the time, not now, now that we've been detaining them for a while, but at the time when they come in or try to seek asylum, I think that there will not be child detention in terms of long term unless it's for the reasons of safety of the child to be sure they're not coming in with a trafficker, or something. But I think that will quickly be, wound up. And I think that Biden and Harris have also committed to naming a commission, working with the ACLU and other immigrants' rights groups, and naming a commission to find the parents or guardians of those 666 children. And that's the latest number from what I've heard is 666. Apart from that, I think that they've talked about forging a permanent path for undocumented students that benefited from DACA. Another thing that the Trump administration had done was since June, they had refused to enforce the Supreme Court's decision that applicants for DACA that met the criteria that had, for whatever reason, whether it was funds, not having the right school records together, had not applied. The Supreme Court had said that those applications should go forward, but the Trump administration had been rejecting them, at least until recently. So I think new applications will be accepted and they'll forge ahead with a plan for a permanent path to residency for DACA, documented students that are documented through DACA or the undocumented students that benefited from Obama's plan. Beyond that, I think that we're going to have COVID more under control before there's more comprehensive reform. I think there will still be enforcement. I mean, the people on the right that say that it's all going to be open borders, I keep hearing that.
Mhm.
I mean, as you know from doing my whole interview, I have family in Mexico that settled in Mexico from Armenia, or what's now Turkey years ago. And my great uncles, we have copies of their visas, that they had coming back and forth. So this whole idea of open border
Yeah.
never really existed, at least between the US and Mexico. And this whole idea that that's what Biden and Harris are about is, I think, so far from the truth. But I do think that some of the things like child detention that are a sore spot for, I would say, many people in this country, whether they're immigration or affiliated or immigrants or not, I think we'll start to see at least a more humane approach to immigration and hopefully some more solutions.
I agree. I'm very happy to hear that. And I'd love to talk to you about that more in the future when we know a little bit more. What about were there people that were deported during the Trump administration that maybe otherwise wouldn't have been? And what happens to them? Do they get to come back?
I mean, it's complicated because a lot of people were deported under Obama too. There was a lot of enforcement under Obama. I think the difference was that there was levels of discretion that the Obama administration allowed ICE officers and attorneys to apply. So if they were dealing with someone sick, with cancer, and I think there were a couple cases like this in 2019 that we saw highlighted at the end of 2019, they could grant something called humanitarian parole and say, go finish your cancer treatment or your child finish their treatment. And then, we'll give some extensions and then we'll see, like, if you can't find something else to file through an attorney with a court that might give you a new chance, a new trial, a new hearing, then eventually we're going to have to move forward. The Trump administration eliminated all that. So literally, you had grandmothers, with no criminal record, sometimes checking in the same as you had a criminal, or someone with something like, probably if they had something very serious, they would be detained. But there should be some levels of enforcement also because we haven't solved this immigration thing this thus far,
Yeah.
the country, Democrats, Republicans, different presidents, everyone, then we can't enforce against 11, 12 million people. So we probably should save the resources for people that are a little higher priority than the grandmother with no criminal record and have
Yeah.
her come in and show paper, over and over again, or we should probably live in a country that's humane enough that we're not going to deport people where their kids are in the middle of, life-threatening conditions. And I don't think these people were criminals, and that the case highlighted. And so we can probably, get back to that. And I think that's what the Obama administration was about. Obama took a lot of heat for deporting a lot of people. And I think, though, that you need a lawyer. You need a lawyer. And I think the problem was some of these people, I would guess, went to non-lawyers or notarios, got their case all messed up. And then sometimes it gets to a certain point where they're at the end of the road. There's just nothing to fix even.
Yeah. Well, it'll be interesting to see how things evolve and what the priorities are of the Biden administration. And I would definitely like to invite you back on sometime to talk about that a little more. In the meantime, though, thank you for sharing a lot of basic information, but still obviously very complicated and nuanced. So thank you for that.
Thank you, Christina.
And if anybody wants to reach out to you to learn more about your services or speak to you about an immigration matter, which again, I remind everybody is not limited just to California, but throughout the United States, what's the best way for them to reach you?
So our website is attorneyjessica.com. That's Jessica. And then they can reach me by email at Jessica, Jessica, at attorneyjessica.com. If you're calling us, also, there's two different numbers. If you're like to call us, if you're from the San Francisco Bay Area or would like to call that number, it's 415-398-4444. And our Central Valley Fresno number is 559-264-2500.
Excellent. Thank you so much. And thank you for watching the Divorce Happy Hour podcast. We'll see you next time.